Hey, good morning, brother. So, you know, you got a good question. You got a great question. A lot of people are going to be asking this question, but I want to draw you back to the truth, okay? Because you're looking at it right now from the wrong direction, okay? You're looking at the end. You're looking at what government did to you, and right now you're defending yourself. You're trying to find a way to defend yourself from the accusations that the state has created against you. You're permitting a conflict to exist, and as a result, you are creating the ability for the state to have jurisdiction to arbitrate in a particular issue, right? Through you defending yourself. You don't need to defend yourself. There's nothing to defend. You need to go on offense, right? And so if a crime is ever committed in the pursuance of any outcome, that outcome must be unlawful because it derives from an unlawful act. So again, don't look at the end. Don't look at what they did to you. Don't defend yourself because, you know, when you start talking about irregularities in the rules of evidentiary procedures, you start talking about the suppression of evidence or tampered witnesses. When you start talking about that, that is dealing with the actual adjudication. You've now moved into an area where there is actually a conflict that exists, and you're permitting that conflict to continue, right? There's no conflict if the court did not have the authority to even be able to oversee your dispute. No authority whatsoever. So, you know, if jurisdiction says that a state cannot be a party when the state is a cause of, or a party in the cause, they cannot oversee it in the disposition of it, then that's the rule. And therefore, when the state took action and summoned you into a court in which they had no authority to oversee that particular dispute, then that's what you need to talk about. Not the irregularities that occurred, not what the prosecutor did or the judge did that denied you certain rights. The court never had the right to be able to even call you in. And so you need to go back to the beginning, right? You need to go to the very beginning and say, did the state have the authority to perform the arrest? And the answer is no, because the state was a party in the cause. The state brought an accusation of a crime being committed by one of their agents, and as a result, that judge has a constitutional obligation to recuse himself. Now, this constitutional obligation, it's not up to you to show him that he doesn't have jurisdiction, because according to Title 28, subsection 455, that a judge has a mandatory, self-executing, non-waivable obligation to recuse himself if, scroll down to item 4, if he is an officer of either party. Now, this is a judicial officer of the state who was a party, and as a result, that judge has the obligation, self-imposed, self-executing, to recuse himself. It's not up to you to make that decision. It was up to the judge to decide whether or not he had a conflict of interest, which he did, because he works for the plaintiff. So the moment that the state took action, right, without lawful authority to take action, every action that they do from the moment that they breach the constitutional obligation, everything after that is unconstitutional, period. So you don't have to go to the end and appeal it, such as you're doing, because that's looking at what the state is accusing you of. That is you defending yourself. You need to go on offense, and you need to point to the fact that the state committed a crime, and the moment you were able to point out that the state committed a crime, nothing that the state did after that point, including the investigation, including the trial, including the sentencing, including none of it is valid. None of it, because the state didn't have authority to do it to begin with. So now I know that the state would like to say to you that you have a statutory limitation on your period of time that you can challenge this, or period of time that you can rescind your particular plea bargain. You know, they would say that to you, but that's once again a lie, because the plea bargain, when did your agreement to enter into the contract, when did that occur? Did it not occur after the unconstitutional act was committed against you, when the state took jurisdiction in a case that they had no authority to have jurisdiction in? So the plea itself is nothing. It's nothing. It doesn't even exist, because before you pled guilty, before you entered into that agreement to enslave yourself and be forced into involuntary servitude in this institution, before that happened, the state had committed a crime. Because if you breach a constitutional obligation, that is a crime, deprivation of rights under color of law. And by that crime, you negate anything that happens after it. So, they can say, well, you entered a plea, therefore, you have a statute of limitations on the amount of time that you can challenge it, the amount of time that you can rescind it, all of these things, but that's not true. Not true at all. You're permitting them to lead you into an area where they have jurisdiction. You are permitting them to create a conflict, and as a result, they have jurisdiction to arbitrate that conflict as long as you permit the conflict to continue. And so when you defend yourself, you are permitting the conflict to continue, and you don't need to. You don't need to, because the state did not have authority. Without a doubt, 100% constitutionally imposed and codified, the state did not have authority to be able to oversee the disposition of that dispute that they were in, because they themselves were a party. And so, what I'm trying to make everybody understand is stop defending yourself, stop looking at the end, go to the beginning, point to the fact that they committed a crime against you, and the moment that you point that they committed a crime against you by taking an action in case they lack jurisdiction, nothing else has to be talked about. Go on offense, accuse them of the crimes that they committed against you. Do not defend yourself anymore, and in doing so, they have to deal with the criminal acts that they committed, which is going to result in the voiding of everything else. Because the maximum law is that any unlawful act at the beginning cannot become lawful over time or by subsequent legislation. So it doesn't matter how long it is, that unlawful act makes it an unlawful outcome. It doesn't matter how many times they've done it, that unlawful act is an unlawful outcome. It doesn't matter if they were ignorant of the law, because their crimes are per se, because their obligations are codified in the law. As a person here, right? If the law says that I won't kill someone, that I won't assault someone, and I turn around and I assault someone, I go to jail whether I meant to do it, didn't mean to do it, whether I understood the law, didn't understand, because ignorance of law is not justification for violating the law. So when the Constitution creates the law and you accept the obligation of it, you're guilty. You're guilty of it, and the actual crime is not what you did, right? We don't have to establish mens rea or anything, because the body of the crime, right, the corpus delicti is, did they have an obligation? Yes. All right. The actus reus is, did they breach your obligation? Yes, they did. The mens rea is, you made a promise to do it because you entered into oath. You said that I will do what the 4 pages of the Constitution says that I will do, and I didn't do it. And I've already implicitly invited punishment in the form of perjury. Therefore, the mens rea is established based upon the oath, period. So what you're trying to do is you're going to the end. You're defending yourself. You have nothing to defend. Go back to the beginning, point out the crime was committed against you in the pursuance of that outcome, and you would do that through a writ of habeas corpus. Because again, a writ of habeas corpus challenges the detainment. It's not a claims processing relief. It's not an appeal. It is challenging the detainment. You are saying that I was unlawfully detained in the beginning, and I want my liberties restored from that unlawful detainment. So if your arrest was unconstitutional, you would use a writ of habeas corpus to challenge the detention, and in doing so, now it's a judicial relief. Now there's only 32 days that the state must respond, or that the court must respond to it. According to the law, that writ of habeas corpus must go to the United States Supreme Court, because that is the only court that has jurisdiction anytime the state is named a party in the cause. The United States Supreme Court is the only court in the country that can have jurisdiction if a state is a party in a cause. That's what the Constitution says. No other court can have jurisdiction. Doesn't matter what Congress says. Doesn't matter what the court says, because all that matters is what the Constitution says. And the Constitution says the United States Supreme Court has jurisdiction, personal jurisdiction, exclusive personal jurisdiction, anytime that a state is named a party. All right. So step back and understand that you're not going to get the relief that you're looking for out at the edge yet, out of the state, because I need to finish my work. But the moment that I finish my work and I show that the Supreme Court had an obligation, and they've been breaching this obligation for 243 years, that was constitutionally codified, the moment that I win that argument, I will send help down from above to empower you with what you need to be able to walk in with a motion to vacate for lack of personal jurisdiction, and that state court will have no choice but to vacate the judgment, because it was made unlawfully by a court that had no jurisdiction to be able to oversee the disposition of that dispute. Okay, brother? God bless you. God bless all of you. Thank you so much for supporting me. Please continue to follow us, and together we shall be free.